Yes,
Lordship, I beg to mention item number 3. This
Item
matter,
3.
yes. If
Let
this
it
matter,
come as per the list. Let it
Pass
come
away,
as per the
Lordship.
list. Yes,
May I please, Your Lordship?
yes.
Lordship, I beg to mention hearing item number 32. Lordship, my senior is indisposed, so kindly list 32, Lordship.
Who's the senior?
He see no him, Lordship.
Pardon?
He see no him. So kindly let the matter be.
Mr. So-and-so. Legal counsel for the petitioner. Legal counsel submits that. Mr. So-and-so, the legal counsel for the petitioner is indisposed, and therefore seeks adjournment of the case for 2 weeks. Where is the law listed accordingly?
Much obliged, Lord.
Yes.
May I please, Your Lordship?
Yes.
Your Lordship, I beg to mention hearing item number 31. My senior is currently out of station, so kindly list the matter on 4th of July.
Mr. So-and-so, legal counsel submits that. Mr. So-and-so, the leading counsel in the case. Mr. Who?
Easy Mommy.
Mr. Edmond, the leading counsel in the case is out of station, and therefore seeks adjournment on 4/7/2023. Where is the law listed accordingly?
Much obliged.
For motion, item number 1.
may it please, Lordship.
Yes, Lord.
Lordship, the petition, there are altogether 28 petitioners, Lordship. They are serving a schedule.
Whether
Labels.
this bench will be the right bench. Whether this bench will be the right bench.
Yes, Lordship. On the earlier occasion, their writ petition was filed before the principal sit. And in the writ petition, they have also stated that it has to be before this honorable court, Lordship, before the Kohima bench. Since the employees are all from the state of Nagaland, Lordship.
I don't know, because we have taken up cases at the principal sit, but I have not come across any case.
Lordship.
So whether this court will be the right court to take up this case.
Lordship. Even otherwise, even the circuit bench is also considered here, Lordship.
Yes.
And the jurisdiction is before this honorable court, Lordship. All the petitioners, they are employees of in the state of Nagaland, Lordship.
Let us just get it confirmed.
Lordship,
Let us
Lordship,
just get it.
Lordship.
Okay, just
Lordship,
revise
Lordship.
it. Okay.
For admission, item number 2.
Yes, what is this case about?
Lordship, it's about a contract, non-issuance of work order, Lordship.
Non-issuance of the work order? This is 2019. Yes, ma'am. What is it?
Lordship, the stand of the stake is that the work has already been completed and payment has also been completed. So the writ petition is infructuous. That's in my.
If you have any grievance, you approach the civil court.
Lordship, there is a diversion on the lay down NIT, Lordship.
So what? The work is completed. Payment has been made. Where is the fund for you?
Lordship, we have filed affidavit in reply.
Your affidavit in reply, okay, but what about the work? It has been completed, payment has been made.
Lordship, it is not as per the NIT. The work is another work. The affidavit in reply we have filed.
Just wait. So if they have diverted the need, what can this court do? You go and approach civil court for damages.
Lordship, page 14 of the affidavit in reply.
So what? There's no money. There's no money for you.
Lordship, it is
How
a
will
central.
this court
Lordship,
sanction the fund?
this is a central scheme, Lordship.
So what? Central scheme or state scheme?
As per the scheme, there should not be any deviation from the.
If there is deviation and if the work has been completed, you go and seek damages in the civil court. Now, how can this court direct the government to give you a separate fund?
Lordship, as per the letter from the Secretariat, in page 14, I have annexed. Let me read the relevant paragraph. Only when the construction was undergoing, the Interdepartmental Verification Committee has given the recommendation for reallocation of the work for construction of road connectivity to AF.
Have you challenged the reallocation?
Lordship,
Have you challenged the reallocation
Lordship.
in this petition?
Lordship.
No, Lordship. He's only asking for that the contract should be given to him.
Huh?
Yes.
No, Lordship.
You have not challenged the reallocation. Your case is that the contract work should be given to you. And if the government has actually diverted the contract and allowed somebody to work, then there's no fund for you. How can this court direct the government to sanction your fund? Come prepared next Monday. We will dispose of. And the court is made up its mind to dispose this case, directing you to approach a civil court if you have any differences. Okay. For the prayer of the also for the parties listed on.
May I please, Lordship? I'm for the respondent 1 and 2. In my counter, Lordship, due to some inadvertent error, I have missed out one annexure. So I may be allowed to submit to the
You file an application for amendment.
Lordship.
You file an application for amendment. But make it sure that you file it on or before Monday.
Lordship.
Okay. Listed on 3/7/2023. You come prepared. Whether this court has the power now to award to actually like sanction you money for the project which you claim to have been diverted.
For admission, item number 3.
Chip, I pray that this matter be passed out for the day.
As for the other side, what is the case?
Matter to regularization, Lordship. This has been partly heard by your Lordship, Lordship. And report was called for.
Regarding what? This is regarding
Regularization of service.
regularization of service.
Yes, law officer.
Pardon?
Law officer in the Department of Prison.
You are seeking for regularization.
My lord.
Whether this court under Article 226 has the power to direct the government to regularize your service.
Yes, Lordship. I'll satisfy you, Lordship, tomorrow.
You read Uma Devi and come. Okay, when do you want it?
Tomorrow, Lordship.
Tomorrow. Okay, also for the. You read Uma Devi and come.
For admission, item numbers 4 to 6.
May I please, Your Lordship?
Yes.
Lordship, the arguing counsel, Dr. Ashok Sharaf from Guwahati, due to severe back pain, is unable to appear before this honorable court. Lordship, may we kindly please
When the pleadings are complete, what is the case?
Yes.
What is the case?
This is about the text.
What is the case about?
The case is about the issuance of taxation order by Additional Commissioner of Taxes against the Indian Oil. Now the matter is for admission hearing, Lordship.
Who's for the other side?
Senior-
State of Nagaland.
Yes,
Mr.
yes.
Moy, you are appearing
I'm appearing, Lord Your
for the
Lordship.
state.
Yes,
Whether you have filed the affidavit,
I filed the affidavit.
okay. And any reply necessary?
Lordship,
Lordship, they have done the reply also.
Okay, pleadings are complete. Listed for hearing in the usual course. Okay.
Lordship,
Lordship, fix the date. Fix the date because the letting counsel is from Gauhati, Dr. A.K. Sarai.
Usual course means after a month.
much obliged.
Okay.
Much obliged.
For admission, item number 7.
Please, Your Lordship. Lordship, today my senior, he has some personal difficulties to appear today. So, Lordship, if this matter may pass over for the day, Lordship.
Who is for the other side?
Yes, Your
Pleadings are
Lordship.
complete.
Yes, Your Lordship.
It is submitted by the parties that pleadings are complete and the matter can be listed for hearing. Listed in the usual course. Okay.
Lordship.
For admission, item number 8.
Yes.
May I
what is
please,
the matter?
may I please, Your Lordship? My Lord, I have received instruction that the petitioner husband is a regular employee and
Has been
that the
regularized.
petition, yeah, yes. So petitioner
What is
is,
your prayer?
Lordship, upon the demise of my father, I seek sought appointment on compulsory
yes,
ground.
my Lord.
Yes.
So,
So we are admitting that the petitioner father was regular employee and as and when his turn come, the matter will be considered, my Lord. I have received instruction, my Lord.
you find your reply, affidavit?
My Lord, I have additional affidavit may be allowed, my Lord.
Mr. E. Kibapo, the Leonard Government Advocate, 6 for 2 weeks' time to file additional affidavit. Where is allowed? This is after 2 weeks.
Much
Obliged,
obliged.
sir.
For admission, item number 9.
May I please, Your Lordship? I am appearing for respondent number 1 and 2, Lordship. I'm here to file my affidavit in opposition, Lordship. Some clerical error occurred, so I may be given a T-dime, Lordship.
One, you are appearing for respondent number
1 and 2, Lordship.
three as 5.
3 is
Three
fine,
more.
Yes,
Lordship.
Ms. Akila, the Leonard Counsel for the respondent number 1 and 2, 6 for 2 weeks' time to file affidavit in opposition on behalf of the state respondents. Where is allowed? Listed accordingly. Okay.
Obliged, Lordship.
Prohibition to number 10.
May I please, Your Lordship?
Yes.
Lordship, by order dated 29/5/23, Lordship, this honorable court has directed to take the state, directed the state respondent to take instruction.
28,
Uh, 20
29,
29/5/23, Lordship.
29. What is the release order from service? Release order from service?
Lordship,
My lord.
Lordship.
What release order do you want?
The employee, the petitioner's husband died. So after his death, his release order is not been issued. That is the order.
Release from service.
My lord.
Lordship.
Yes, Mr. Veto, what is taking you so long?
Lordship, I have the instruction with me,
Let's see.
Lordship.
Have you read? Have you given a copy to him?
Lordship.
Yes, read it. Yes.
My lord, in that case, let them be the salary. If they are not going to release somebody.
No, your husband was serving.
My lord.
Your husband was serving.
My lord.
And he retired or
He
died
died.
in harness?
Died in
Died
harness.
in harness.
He died in harness.
My lord.
Lord.
So literally there should be a release order for the deceased person.
Lordship, here in this case, the petitioner has not been retired, but he died in harness while serving in the department, Lordship.
At
So
least there should be some record to that effect.
there will be a record. But however, as far as release order is concerned, release order, the department does not issue a release order to those who died in harness.
No, at
That
least
is,
the release order may not be issued, but at least
Since-
a certificate stating that he died in harness and so and so. Since he did not actually leave service on retirement.
Lordship. Lordship, at the time the petitioner husband died in harness, Lordship, at that point of time, the petitioner was holding he was serving as a work charge.
Work charge.
Work charge
Lordship. Work charge
for how many years?
for
16 years.
16 years. For how many years?
16 years, 1 month, 13 days. My lord,
What are you claiming in your petition?
my lord,
What are you claiming?
service benefit of a disease.
Service benefits.
My lord,
You appeared recently in your case before a division bench?
my lord,
Yes.
yes.
That covers this.
My
Lordship.
lord. However, my lord, if the government don't want to give a release order, let them file it in the affidavit form. So that it will be before your lordship.
It will not serve any purpose.
Lordship,
lord, whatever
it's
it
not
is.
going to
Will not
serve
serve
any
any purpose in
purpose,
your
Lordship.
case.
Yes, Lordship.
It will not serve any purpose. Whether the government issues your release order or not, it will not serve any purpose. The only question is whether you have a right
Lordship.
to be regularized for pensionary benefits.
My lord.
That has been settled. You have no right. Settled. Come prepared for hearing next week.
My lord, let it be listed after vacation.
After vacation.
My lord.
On the prayer of the learned counsel for the petitioner. List it immediately after the summer break.
My supply.
For admission, item number 11.
Please, Your Lordship. Lordship, as per the last order dated 8/6/2021, 2023, the last opportunity was given to the present petitioner, Your Lordship, to file affidavit in reply. Your Lordship, my humble submission is that,
What is your prayer?
Your Lordship, I'm praying for regularization, posthumous regularization.
No, you don't have a case.
No, Your Lordship, but my humble submission is that when
All posthumous regularization worked out for the purpose of pensionary benefits is covered by the recent judgment.
yes,
Division
Your
bench.
Lordship, but I may be given one last opportunity to satisfy this honorable court, Your Lordship.
How can
At
you
least file my
satisfy?
affidavit.
You have to appeal against the division bench order. How can you satisfy this court without appealing against that order?
Yes, Your Lordship, my humble submission is that that case was passed on this different set of facts and it has no application in the present case, Your Lordship.
The ratio is applicable. Ratio is applicable. The ratio is laid down by the division bench.
Your Lordship, but my humble submission is that I may be given one last chance, Your Lordship.
Last chance for what?
To do
You
some
have
more
taken
research, Your
another
Lordship.
case. You were given the last chance to file affidavit in reply.
Yes, Your
You
Lordship,
have not filed.
but I need some more time to do research, Your Lordship. So,
Don't do research. Appeal against that judgment. Research
Yes.
will not help you.
yes, Your Lordship.
Research will not help you because actually I remember all this kind of cases. The learned councils, they were mentioning that this case is covered by that Alambas case, which is pending before the division bench, and therefore the case should be listed after the disposal of the matter by the division bench. Almost in all the cases, that prayer was made. Now that case has been disposed very clearly,
Yes, Your Lordship.
very clearly, saying that if you are not eligible in terms of the scheme, no regularization.
Here, Your Lordship, the petitioner is not seeking regularization as per the scheme. Your
Then
Lordship,
your case is worse again.
Your Lordship,
Because under 226, where is the power of this court?
the present petitioner is seeking regularization as per the Nagaland Dobashi Service Rules Act, Your Lordship.
Your Lordship, the petitioner was a contingent employee, so the Bashi service rule does not cover the petitioner, Your Lordship.
Your Lordship, the petitioner's husband, he was appointed as contingency Dobashi, Your Lordship. And as per the Rule 9 of the Nagaland Dobashi Service Rule, Your Lordship, on completion of 3 years of qualifying service, Your Lordship, if the persons shall, if considered fit for permanent appointment, be confirmed in their appointment, Your Lordship. That is the rule, Your Lordship. And the petitioner's husband, he...
For that, you approach the government. You approach the government. How can this court give such a direction?
Yes, Your Lordship,
How can this court
I
give
have
such a
already made
direction to confirm
representation.
you or to regularize you?
I've made a representation, but however, it was not considered. So I'm approaching this honorable court, Your Lordship.
Okay, you find your affidavit in reply.
Yes, Your Lordship.
I'm prepared to dismiss your case.
Yes, Your
So you
Lordship.
come prepared
Yes,
to
Your Lordship.
defend yourself. Okay?
Yes, Your Lordship.
MS so submits that the matter may be listed after the summer break. Listed immediately after the summer break.
Deeply obliged, Your Lordship.
Override petition, item number 12.
Yes, what is your case?
Yes, my lord, this is for invalid pension, lordship.
Invalid pension.
Lordship.
What is the gist of your case?
Lordship, here the petitioner was appointed as constable way back in 1983. Lordship, may kindly turn to my petition. Annexure 1 is his appointment, the petitioner appointment. A type copy will be, Lordship, will see at page 15. So this is the initial appointment of the petitioner, Lordship. Now, Lordship, while he was on service, and then when he was on a date with the then commandant, he met with an incident, and then his fingers was chopped out, two of his fingers, and then thereafter he was his invalid pension was forwarded, and then accordingly his invalid pension was approved. Lordship, may kindly turn to the annexure 3 of my petition, Lordship. This is the approval of the invalid pension. Now the Lordship type copy is at page 18. If I am allowed to read, Lordship. Subject is release order from service on invalid retirement. You are hereby informed that your application for leaving service on retirement has been approved by the Director General and Inspector General of Police, Nagaland White Letter Number Section Such, dated 18/191. You are hereby released from the unit with effect from the 41 of 1/491, and the following documents information may be submitted to this office for process of your pension case to the head of department. And then those are the requirements which the petitioner is supposed to submit. Now, Lordship, what happened, Lordship? After the submission of this, his documents, this and that, his pension was not considered. So he made a reminder representation. That is at page 19, annexure 4. And then also, Lordship, his resignation was not considered. So again,
Your pension was first considered.
approved, Lordship.
Approved.
Approved.
Approved, then what happened?
Lordship, despite of the approval, I was not given the invalid pension. So I have
Your
approved
invalid pension was approved by whom?
by the approval of the Director General, and then this order was given by the Commander, Lordship, as per his annexure 18, Lordship. If you kindly, Lordship, to look into that.
Let's see your annexure.
Annexure
Well,
3,
where is that approval order?
page 18.
Page 18.
This is a type copy, Lordship, for more clarity, Lordship.
Page 18.
Yes. Now,
Where is the original?
original is at page 17, Lordship. So, since it is not that clear, we have made the type copy, Lordship. So, the subject is, Lordship, release from service on invalid retirement. And now, reading to the body of the letter, you are hereby informed that your application for leaving service on retirement has been approved, Lordship, by the Director General and Inspector General of Police, Nagaland, White letter number PHQ/bent/1684/90, dated 18/191. So this is the clear approval letter made by the
This is approval for
invalid pension, Lordship. And then this order was issued by the
no, not for invalid pension. You read it carefully. You are hereby informed that your application for leaving service on retirement has been approved. So this is not retirement. You read it properly.
Lordship, yet release order on service invalid retirement, invalid.
You are hereby released from the unit
Invalid
with effect
retirement.
from the-
Invalid retirement, Lordship. And then this has been approved by the Director General and Inspector General of Police. And then on these facts and circumstances of my
You first satisfy this code on this 18, page 18. Don't
Yes.
go further. I'm on this.
yes, Lordship, that is why
Your
on
application for leaving service on retirement. Where is your retirement order?
No, basing on this, I was released from service, Lordship. I'll come to that, Lordship.
Your application for leaving service on retirement.
Yes, yes, yes.
Your application for leaving.
So, Lordship, as I stated, on the facts and circumstances of the incident,
You please satisfy this score on page 18.
Lordship, that is why I'm coming to that. Invalid. I think that the word itself invalid.
Where is that invalid pension?
Retired release order from service on invalid retirement, Lordship. And
Where,
then, Lord,
where is that invalid retirement? You are actually adding word to this letter. I don't find that
no,
invalid.
this is order of the authority, Lordship.
Where is that word invalid?
It is subject in the subject itself is very clear mentioned, Lordship. And then this has been approved. And then see, Lordship, my humble submission on the facts and circumstances of the incident, my invalid pension has been forwarded by the district authority, and then this has been approved, clearly approved by the Director General, Lordship. And then basing on this, I have been released from the service. The release order is at page 15, Lordship. Lordship may kindly turn to page 15. This is a type copy. The original copy is at page 14, Lordship.
Page 15?
So this is, Lordship, this is initial
This is your appointment.
Yeah, this is appointment. So, Lordship, if you kindly read the second paragraph of this page 18, I have been released from the service, Lordship, page 18. You are hereby released from the unit with effect from the forenoon of 1/4/91, and the following documents information may be submitted to this office for process of your pension case due to the head of department. So, this is clearly mentioned, Lordship. I've been released from the service, and then I have been directed to submit some documents, relevant documents, for forwarding the pension, Lordship. So here the pension.
Who is the authority to give you pension? Who is the authority? Whether it is the DGP or it is the government?
Lordship, since my administrative head is the DGP, my case has been forwarded by the district head.
DGP is not the administrative head. DGP is only a director.
Lordship, this is on this strength, I have been released from the service, Lordship. And then I'm nowhere in
Yes, Government, what is your stand?
Your Lordship, the petitioner here, he did not qualify the length of service, did not allow him to qualify for invalid pension. He was in service for just 7 years, Your Lordship.
What does the law says on invalid pension?
Lordship, we are following this central service rules, 1972. There, under this rule 38, the invalid pension nowhere indicates about length of service. No doubt, after some hearing on the last occasion, the learned friend has submitted that I am shortage of length of service, not reaching 10 years. And then on that, he has submitted additional affidavit, enclosing the notification issued by the state government. So, Lordship, I'll come to that. Additional affidavit filed by the respondent 1, 2, and 3. In their annexure, this is the office memorandum saying that, Lordship may kindly turn to the page 6.
Whether you are qualified for this invalid pension under CCS pension?
Lordship,
I'll you give me that provision.
Yes. So before that, I want to make a submission on this. This office memorandum was given on 22nd December 2015. Whereas in the central service rules, nowhere indicates about the length of service for invalid pension. If it is a normal pension, then it may be for 10 years. No doubt, Lordship.
What is the qualifying service for invalid pension?
There is no qualifying service for invalid pension. That as per the Rule 38 of the central service rules. But no doubt, Lordship, we have brought this notification by way of making additional affidavit by this annexure. But this amendment, that this office memorandum has been amended. Here, notification is 2015. Mine is 2019 has been amended. This one, this notification. So I'll place before this.
What is the 2019?
Lordship, I'll place before. Lordship. Lordship, this is the gazette issued by the government of India, Lordship. I may be allowed to Lordship actually. Subject is grant of invalid pension under Rule 38 of the Central Civil Services Pension Rules 1972. Clarification regarding Lordship. The undersigned is directed to say that Rule 38 and Rule 49 of the Central Civil Service Pension Rules 1972 have been amended by notification number 21-1-2016 PNPW F dated 4th January 2019. This is important, Lordship. Copy enclosed. The proviso to the amended Rule 38 of the CCS pension rules provided that a government servant who retired from service on account of any bodily or mental infirmity which permanently incapacitates him for the service before completing qualifying service of 10 years may also be granted invalid pension in accordance with sub-rule 2 of Rule 49, subject to the condition that government servant, clause A, was examined by the appropriate medical authority either before his appointment or after his appointment to the service of post and was declared fit by the authority for government service, and P, fulfill all other conditions mentioned in this rule for grant of invalid pension. Now, 2 is important, Lordship. In this connection, it is clarified that condition of qualifying service of 10 years for grant of pension under Rule 49(2) of CCS Pension Rules 1972 shall not be applicable in the case of a government servant retiring or invalid pension on account of any bodily or mental infirmity under Rule 38. Accordingly, invalid pension at a rate of 50% of emolument or average emolument, whichever is more beneficial, subject to a minimum of 9,000 rupees per mensium and maximum of 1,25,000 rupees per mensium shall be payable to the government servant who retires under Rule 38 of CCS Pension Rule 1972 even before completing a qualifying service of 10 years. So this is very clear, Lordship. And then this is what this has been published by the Gazette of India, Lordship. The Gazette of India, Extraordinary, Part 2, this is the Gazette. So the state respondent which they have submitted that I am not qualified, their notification is 2015, whereas this is the latest amendment as per the notification, office memorandum. So in lieu of this, in brief, Lordship.
Ms. Ayami, you get necessary instructions on this.
Yes, Your Lordship.
Because actually you have a government notification which says that the petitioner is not eligible for invalid
Yes,
pension.
Your Lordship.
But as per this notification, this is 2010.
19, Lordship.
19, sorry. As per this, the petitioner seems entitled. So kindly get necessary clarification. Those pension matters, the government is coming up with so much of notification, there is no clarity. Whether CCS pension rules 1972 is applicable,
Yes, Your Lordship.
it's applicable.
Yes,
You come with more better clarity on this. Have you given a copy?
Lordship, I'll give you.
Can you give her a copy? And Mr. Counsel, Lieutenant Counsel for the Petitioner, and MSAIME, the Lieutenant Governor Advocate. Stop. The Lieutenant Counsel for the Petitioner as placed the office memorandum dated 2/2/2019, issued by the Government of India, Ministry of Personnel, Public Grievances and Pensions, within bracket, Department of Pension and Pensioners Welfare, in support of his claim that as per the OM issued by the government of India, the petitioner is entitled to invalid pension, even if he has not completed the qualifying service of 10 years. So, Ms. AIME to give necessary instructions on the office memorandum raised by on the office memorandum dated 12/2/2019, submitted by the learned counsel for the petitioner. Listed after 2 weeks. The office memorandum dated 12/2/2019. Shall be kept in the court. Yes.
For admission, item number 13.
Yes.
Lordship, this is a challenge to the regularization of.
Lordship, in this case, more mention is appearing, Lordship. If this matter can come up after the listed matter, Lordship.
What is the matter about?
Your Lordship, the petitioners and the private respondent, they are contingent drivers under the Planning and Coordination Department, Your Lordship. There is a seniority list also. The private respondent comes under serial number 4. Now, the petitioners, when vacancies arose, the petitioners approached this honorable court by way of a writ petition, because persons who were indirectly appointed, by way of backward appointment. So we challenged their appointments, and the decision was rendered by this honorable court and in that direction was given to consider our case in terms of the standing government notification. While matters stood thus, instead of considering the petitioner's regularization, the private respondent who is way down in the list was regularized. So we have approached this honorable court by way of his writ petition challenging his regularization. We are not saying that he will not be entitled, but he should go by the seniority list. That is my only case.
Yes, Mr. Ma.
Your Lordship.
For the private respondent,
Yes, Lordship, I'm for the private respondent.
you are below the petitioner.
Lordship, I agree that.
Then
Lordship.
how can you supersede him?
Lordship, in a similar case, which was filed by the same petitioner's Lordship, a petition was filed before this honorable court, challenging the appointment of 2 private respondents on the ground that when the vacancy arises, the senior most has to be considered. In that sense, the 2 senior most has to be considered, Lordship. Being aggrieved, there was a appeal filed before the Honorable Division Bench, Lordship, and also a counter appeal was also filed. Read Appeal 6 and Read Appeal 15, Lordship. This Honorable Court has also heard the matter, Lordship. Your Lordship was also a member of the bench, Lordship. Now that appeals has been disposed, Lordship. And at paragraph 30 of that judgment and order, Lordship, it has observed that the petitioners, they are yet to qualify the length of service of 30, Lordship, in terms of OM 17 March 2015, Lordship. This Honorable Court has, by division bench, has held that, yes, contingency employees are also applicable as per the OM, Lordship. However, they are yet to qualify that 30 years length of service, Lordship.
And you have qualified.
No, Lordship, I have not qualified, Lordship. In terms of that, Lordship, neither the petitioners are also not qualified, Lordship, and they have no locus to challenge, Lordship.
You are also not qualified.
Lordship, I agree, Lordship. At the most, the senior most amongst the 6 petitioners, Lordship, he has served only 21 years of service. I have a copy of the judgment, Lordship. Protect. Case cannot be considered, Lordship.
Both of you are not entitled. As per that, this OM 2015, and as per the judgment, were
Yes,
you
Lord.
not entitled? So when you are not entitled, how do you hold the post?
Lordship, my respectful submission, Lordship, for all fairness, Lordship, if the post can be advertised and all the eligible candidates can participate, Lordship, instead of considering the petitioners, Lordship, they are not eligible, Lordship.
If you are not eligible, I think the only option is to throw up the post for advertisement.
Your Lordship, the matter is under consideration presently. That it is Honorable Court, if your Lordship may go through the judgment, Your Lordship. The last part, one page, Your Lordship. Page 27, paragraph 30, Your Lordship. If I may read. On the basis of the above findings, an important issue further arises.
You are reading which paragraph?
Paragraph 30, Your Lordship. Paragraph 30. Last part, one page.
Yes.
On the basis of the above findings, an important issue further arises for consideration as to whether the posts which have fallen vacant in view of the setting aside of the appointments of the respondent number 3 and 4, appellants in writ appeal number so and so, are required to be taken into consideration for regularization of the services of the petitioner, the appellants in writ appeal number so and so, or the said posts are required to be filled up in terms with a direct recruitment by the NPSC. Clause 1.2 of the Office Memorandum dated 17/3/2015 stipulates that it is applicable to those work charge and casual employees who have completed or will complete 30 years of continuous service after 1/1/2015, meaning thereby the right of the petitioner writ appellants to be regularized would only arise after they render 30 years of continuous service, and at present the petitioners are yet to complete the 30 years of service, taking into account that the petitioners at present are not eligible. This court cannot issue a mandamus directing the respondent states to keep the post vacant till the petitioners become eligible. The respondent state would be at liberty to take such course of action as deemed fit as per its existing policy. 31. We further make it clear that the OM dated so and so would also continue to be applicable in so far as the same is not inconsistent with the Office Memorandum dated so and so. So now the matter has been put up before the government for consideration. It is in the process. So, Your Lordship, even if we may not be found eligible, Your Lordship, but if, as and when we are found to be eligible under the scheme, it has to go by the seniority list.
That will be after how many years?
Your Lordship,
If you are to be eligible under the scheme.
yes, whatever it is, but they cannot
Not
regularize.
whatever it is.
Yes.
You will be eligible after how many years?
Your Lordship, I right now I don't have the. I'll have to go through the petition itself.
No. How many years
Yes.
you have been serving?
For more than 20 years, above 20 years. Your
Above
Lordship.
20 years.
Yes, above
So you
20
still have
years.
about 10 years to go.
Yes.
Lordship,
But, yes, but
the
whatever.
senior most is serving for last 21 years, Lordship.
The
The senior most amongst all the 6 petitioners,
Yes.
Lordship. 21 years.
So it has to go by, if at all they are to consider our regularization, it has to go by the seniority.
And if nobody is eligible,
Then
it has to be advertised.
yes. But here, the only case is that we are all in the same boat. When we are all in the same boat and there is a seniority list mandate, they cannot pick and choose among us. If at all,
See,
they have to consider
as per the
regularization.
scheme,
Yes,
the government has mentioned a seniority list.
yes,
And as per the seniority list, none from the seniority list is eligible for the
Yes.
post. What is the other option? The other option is for the government to advertise the post. The government cannot leave the post vacant like that.
So, it is going by the judgment of the division bench, Your Lordship. So if a direction may be given to consider it in terms of the division bench order, that will suffice, Your Lordship, in the instant case, because the division bench case itself covers the present case.
What is the direction of the division bench? What is the direction?
Your Lordship, the respondent states would be at liberty to take such course of action as deemed fit as per its existing policy.
As per the?
As per its
What is the existing policy now? What is the existing policy?
Existing policy is?
What is the existing policy?
The 2017?
2015?
Yes.
Yes.
2015 OM.
Exactly. That's why. And if you are not eligible under the 2015, what is the next recourse?
Your Lordship, the matter, since it is covered by this judgment, even
I don't think so. I don't think so.
Your Lordship,
the situation is a little bit different.
No,
no. Let us try to
is-
assess one another.
Okay,
Let us
Your
try to
Lordship.
assess one another. But what I'm saying is that as per this order, no one is eligible.
Your
So
Lordship.
as per this order, a direction is given to consider the case as per the government policy.
Yes.
As per the government policy. That's
Yes.
why I'm asking you, what is the
Yes.
government policy? What is
As
the
per
government
two-
policy?
As per the 2015.
That's why, again, we're
Memorandum,
coming back to
yes.
square one.
Yes. So Your Lordship,
2015, if no one is
Yes.
eligible under 2015,
So
then
my-
what should be the next recourse for this court?
Your Lordship, since this judgment arises.
I am asking you to assist the court.
Yes, Your Lordship. That is why my humble submission, Your Lordship, is. My humble submission, Your Lordship, is. Since the division bench has clearly directed that go by the existing policy, and this petition also arose from the same judgment, Your Lordship, on the basis of that the single bench judgment had come out when the present respondent was regularized. So that the judgment has also been annexed here in Your Lordship, in this petition. So when this matter was pending again, the appeal was preferred and this judgment was rendered, Your Lordship.
So
now,
you want this court to go by this judgment, correct? By this
Your
division
Lordship.
bench judgment. Now to go by this division bench judgment, we have to follow the existing policy.
Your Lordship.
That is the question.
Your Lordship, yes.
Now, what is the
Now
existing policy?
The existing policy is the 2015.
Exactly.
Your Lordship.
So if you are not qualified under 2015, what is the next recourse? That is what the court is asking.
The government is, the matter has been put up to the government for consideration, Your Lordship. It is off the record, but after this judgment was rendered, the department considering our case, they have put up our case for regularizing 50%, Your Lordship.
Regularizing?
Regularizing 50% of those serving candidates and the 50% for advertisement. That matter has been put up and it is under process before the BNAR department presently, Your Lordship.
Okay.
That is my information so far received from the petitioners. Now here in this case, even if they consider 50%, the present respondent has to be considered under that 50% only among all the petitioners. So what happens is that since he has to wait for his turn.
So your submission is
my
that
submission
to
is
keep the
that-
matter pending?
No, Your Lordship,
Till the government takes a decision?
the matter may be disposed of, quashing and setting aside the regularization of the private respondent, and go by the direction of the Honorable Division Bench in the read appeal.
No. I will actually direct the government to advertise the post.
Your Lordship, I leave it to Your Lordship.
We'll go
I
by
leave it
that.
to Your
Yes,
Lordship.
Mr.
If Your
Mohan.
Lordship deems it necessary.
Yes.
Your Lordship, as my friend has read out the para 30, page 29, the state respondent would be at liberty to take such course of action as deemed fit as per its existing policy. And then here, the division bench has made one observation. We further make it clear that the office memorandum dated 22/9/2004, that is 50-50%.
2009,
Four.
2004.
No, 2004. 22/9/2004. Would also continue to be applicable and so far as the same is not inconsistent with the office memorandum dated 17 March 2015. That means we have two state memorandums for regularization of work and casual employees. One,
Miss
2004.
Sokre. Yes. Miss Sokre. whether 2004 notification has been set aside by that 2022 judgment, 2023.
No.
By implication, let us read the judgment, the latest judgment.
The latest judgment, Your Lordship, in my opinion, both the two are in operations. And the latest judgment that deals only with the star DC.
No, let us read the
Yeah.
judgment, no, because it's really this judgment says that the 2004 shall be applicable in so far it is not inconsistent with 2015.
Yes, 15.
In so
Yes.
far it is
Yes.
not inconsistent.
Yes.
That Alambas judgment says
Yes.
that by implication,
Yes.
2004 notification shall stand nullified. By implication. I want to see the judgment. I think I have read the judgment 2-3 times.
Mm.
Maybe I think I may not be right,
Mm.
but well, what is that case number? 27 WA 27 2020.
Yeah, Pancha, you got it.
See, Mr. Tongpo, 2004 notification has not given the qualifying years. Correct? That
Yes.
30 years was introduced only by 2015 notification.
Yes, under
Correct.
the 2004 notification, 50% of every vacancies are right.
But now,
Yes.
since 2015 notification has come into being,
Yes.
whether the qualification, even for that 50% or whatever percent, even for actually availing that, you have to qualify the service of 30 years.
No, a distinction has been made in this judgment by the Honorable Division Bench in that those who are appointed on work charge basis, they are entitled to the 2004 notification. For contingency and appointments under other nomenclatures, since it is not specifically, since the 2004 is talking specifically about the work charge only, the 2004 notification applies only to the work charge. That is the finding of the division bench here in this judgment. And for contingency and casual employees, the 30 years will apply. That is the
No.
That is
But
the
as per
finding.
if
Yes.
that is the reading of 2004, then I think 2015 has superseded that, because 2015 speaks about work charge and casual employees.
Yes, Your Lordship. In 2000,
So that 30 years is for work charge and casual
yes.
employees.
That
You cannot
was-
escape that.
That was my case. And even the affidavit which was filed by the state respondents, it was also in that similar line, but because of the specific language use and work charge. So the 2004, and it has been incorporated in the 2015. also,
What
Your
is
Lordship.
that case,
Yes.
Madam Sakre? WA 227,
It's regarding with regularization of work charge.
WA 27,
27 of 2022.
WA 27 2022. Please get that. WA 27
7 of 2022.
2022. I think by implication in this judgment, by implication, this 2004 has been set aside.
I haven't seen the judgment, Your Lordship.
So if there is any confusion in the order passed by the division bench, then the right thing for this court is to take recourse as per the law to advertise the post.
But if the
And if any person is aggrieved,
Yes.
the higher court is there.
Lordship, I have no issue with that. My only case is that we are all in the same boat. We should be, if at all we are to be regularized, it has to be in accordance with the seniority. That is my only case here.
In accordance with seniority, no one is eligible.
Yes, if we are found to be ineligible, then he is also ineligible.
Ineligible. That's why what is the best recourse is to advertise.
Your Lordship, it is up to your Lordship's judgment now. But my humble submission is that since the division bench order is there, if a judgment can be passed on the line of the division bench, that the matter be considered in accordance with the division bench judgment. That is
Division
also,
bench
that
judgment
would-
says
that
as
would
per
also
the policy,
suffice.
existing policy.
Yes, Your Lordship. So
That is where the confusion arises.
No, the division bench judgment is very clear, Your Lordship.
As per the policy.
As per the policy, that means it has to go by the policy. The government has to decide in accordance with the policy.
Though anybody
So-
go in appeal, we will dispose this case, directing the state to advertise the post.
Your Lordship, so long as our prayer in the petition is.
Anyhow, let us keep this in the revised list. Just
Yes,
let us see that order. Let us
Your
see that
Lordship.
order.
Your Lordship.
Okay, which was passed in WA 27/2022.
Your
Let
Lordship.
us see that order.
Your Lordship.
Yes. Yes, revised.
Regarding the motion.
Yes. Read it. What is it? Maybe directed to be listed. Read appeal, read petition against read appeal, read petition against with respect to service of matters of judicial officers, employees of the High Court. This is not for this.
Those are to be listed in division bench.
No, but this has to do with matters of judicial officers, employees of the High Court. Call Mr. Anop. You give that and call Arnold also. You give that. Mr. Ma, I think yes, this. You give that.
WA 27.
Yes. Yes, let us continue with that case. Where is Mr. Tongpok?
Lordship, that one is mentioned at paragraph 8. In the last paragraph, yes, it is.
Yes, now see. Now you see this order. This order was passed in that case, Alamba.
Yes.
Although there is no indication in the notification as to whether the scheme introduced in the year 2015 supersedes the earlier scheme of regularization, yet by necessary implication, it can be presumed that the scheme of 2015 has replaced the previous scheme and is holding the field. See, replaced.
Lordship, but according to my opinion, this
Not
is just
according to your opinion,
no,
according
no,
to this.
No, so this is only just an obiter dicta, not this is a final observation of the court. This is just the observation of the court. It cannot be taken as a precedent, Lordship.
Then let the government come up with a very clear thing, because actually, because the government, I think, is not coming up with a very clear stand on 2004 and 2015 notification. It is creating all this sort of problem for the court.
Lordship, for 2004, it is general. It's applicable to the scale of pay and the fixed of pay, basing on the seniority. But the 2015 is that a person should enjoy scale of pay and should complete 30 years, Lordship.
I'm still confused with 2004 to 4. What about the judgment, earlier judgment of the division bench, which says that actually uh, wherever the 2004 notification is not inconsistent with
Yes.
2015, the 2015 notification shall operate.
Yes, yes.
What does it mean? So 2004, 2015 notification has to be applied, and only when there is any like inconsistency, 2004 notification has to be put into operation. This is confusing. You tell the government to come up with something very clear. This is time and again I have been repeating that I'm still confused with 2004 and 2015 notification. There is no clarity. There is no clarity on this. That is why actually these matters are always coming before this court. I think you will have to do some sitting with the government now for this 2004, 2015. If you are saying that the judgment passed by this court in Alamba is obiter dicta, if you are saying that the judgment passed by the Honorable Division Bench in Alamba's case is obiter dicta, then in that case, the matter, the issue still remains unresolved. So you have to resolve, because it is not for the court to actually frame the scheme. It is for the government to come up with some clarity.
If 2004 is still in
that is-
existence, then it will be to the advantage of the
Yes,
World Church employees.
and if actually like the government stand is that 2004 and 2015 still operates, and to the latest judgment passed by the division bench is obiter dicta, then what is the point of actually the division bench and this court passing so much of orders when the confusion still persists? The confusion still persists. So will it not be proper for the government to come up with a very clear scheme? Just one scheme, instead of 2004, 2015, always having some contradictions.
Lordship, otherwise, it's very clear. The 2004 is that it is a general. It covers the fixed pay as well as the scale of pay, basing on the seniority. So even if he did not complete the 30 years, or so, if he is the senior most, he
what
can
I'm
be
saying, madam.
regularized. But in the 2015, it's only for those scale of pay.
No, so if 2015 covers only those person who has completed 30 years,
Yes,
will 2004 not become redundant?
it is still inapplicable. That is
It
what
is still
yes.
inapplicable, but it is conflicting. See, in spite of the division bench passing this judgment, we are still always continuously arguing on this. So is it not for the government to at least come up with some clarity?
Lordship.
If not, this problem will persist,
Lordship.
and we cannot say that it is the fault of the lawyers. We can only say that it is the fault of the government for not giving clarity. And if there is no clarity for the lawyers, and an occasion may come when the 2004 memorandum will support them. Another occasion will come when 2015 notification will support. So this problem will go on and on. That is why I have requested you even on earlier occasion Why don't you at least have a sitting with the government on this 2004-2015 notification? Please do that. Wait, this is no. Yes, so we will list it after some time.
Your Lordship.
This is quite confusing. No. So which is that case? That case? This is Mr. Tongpok. This is WPC 138. Correct?
Yes.
Listed immediately after the summer break. I think you come with some solution. If not, this court will strictly go by Omar Devi.
Your Lordship.
No policy, no scheme, nothing.
Your Lordship.
We'll go strictly by Omar Devi. Okay. Yes, Mr. This is regarding with court or judicial officers. But this is a case. So with this kind of cases. You go through this case, no? Mr. Moa, your motion matter, let it come up tomorrow.
Lordship.
Because there is some confusion.
Lordship.
Let the registry clarify.
Lordship.
Okay?
Lordship.
Motion matter. Pass over for the
For admission, item number 14.
May I please, Your Lordship?
Yes,
Lordship,
yes.
I may be given 3 weeks' time to file counter.
Okay. Okay.
Lordship.
MS V. Sokre, the learned additional advocate general, 6 for 3 weeks' time to file affidavit in opposition on behalf of the state respondents. Prayer is allowed, listed accordingly. Okay.
For admission, item number 15.
Lordship, I've received the affidavit of the state respondent, Lordship. If this matter can come up on 4th, I've taken the consent.
4th of July.
Lordship. Next
what
week.
is
Tuesday.
4th, I don't know. What is the matter about?
Lordship, it's regard to selection of VCM.
VCM?
Yes, Lordship. In fact, the matter was listed for today, but since the government has filed the affidavit, we were given the last chance, and I've received the affidavit and I've sent it to the petitioner's Lordship for certain clarification.
Okay, then in that case, we have it after summer break.
All right, fine.
Okay, we have it after summer break.
Lordship.
Where is that file? Mr. N. Muzui, the learned counsel for the petitioner,
Lordship.
submits that he has received a copy of the affidavit in opposition filed by the state respondents only today.
No, Lordship.
Only recently.
Recently.
He therefore submits that he may be allowed some time to get necessary instructions from the petitioner.
Lordship.
Prayer is allowed, listed immediately after the summer break.
Lordship. Obliged, Lordship.
For admission, item number 15.
Yes, Mr.
Your Lordship, I need some more time to file an affidavit.
Okay.
So this matter will list after summer break.
Yes, and ma'am, you are for?
Respondent 1 and 2, Lordship.
Respondent 1 and 2.
Yes, Lordship.
And Ms. Imti, you are for?
For the state.
State is respondent number
3 to 7, Lordship.
3 to 7.
3 to 7?
Yes.
Okay. Have you filed your affidavit?
Yes, Lordship.
Your file?
Yes, Lordship. Yes, Lordship.
Okay. Mr. Imtimson, the learned additional advocate general for the state respondent number 3 to 7, 6 for 3 weeks' time to file counter affidavit on behalf of the state respondents. Prayer is allowed, listed after 3 weeks.
For admission, item
Any
number.
interim? Huh?
No, Lordship.
Okay.
Item number 16. Number
This is
16.
item number 16.
16.
Okay.
Item number 16 was called out just now, Lordship. So I think it will be 17.
Item 16 called out. So it will be item 17. Item 16 is 50. Item 16 is WPC 50.
Yes, Lordship.
50, it has been called out. It will be item 17.
For admission, item number 17.
Yeah, please, Your Lordship. Lordship, here I'm yet to file counter, so kindly grant 3 weeks' time, Your Lordship.
Where's the file? Okay.
Lordship.
MSc Nauli, the learned government advocate, seeks for 3 weeks' time to file affidavit in opposition on behalf of the state respondents. The same is not objected to by the learned counsel for the petitioner. Listed after 3 weeks.
Much obliged, Your Lordship.
Item number 18.
May I please, Your Lordship?
Yes, yes, please.
3 weeks' time might be granted to file our reply to the affidavit filed by the respondent 5, Your Lordship.
Who has filed the affidavit in opposition?
Private respondent number 5.
State.
No, private
Respondent number 5.
Oh, respondent number 5. So you want, Moa, you have filed?
Yes, sir.
So you want time to
3
file
weeks.
reply
Yes, Your Lordship.
to the respondent number 5.
Respondent number 5.
Okay, MS so-and-so. The learned counsel for the petitioner. 6 for 2 weeks' time to file affidavit in reply to the affidavit in opposition filed by the respondent number 5. Prayer is allowed. Listed after 2 weeks.
Lordship, there's an interim.
Pardon?
Interim.
Stop. The interim order passed earlier shall continue till the next returnable date. Okay.
For admission, item number 19.
May I please, Your Lordship?
Yes.
Your Lordship, on the earlier occasion, I have sought for time to file reply to the additional affidavit filed by the petitioners.
Okay.
So kindly grant me 3 weeks' time.
Okay.
Lordship.
MSc IME. 6 for 3 weeks' time to file affidavit in reply to the additional affidavit filed by the petitioner. Prayer is allowed. Listed after 3 weeks.
Much obliged, Your Lordship.
For admission, item number 20.
May I please, Your Lordship?
Yes.
Your Lordship, in the last occasion, this honorable court was gracious enough to give me time to seek information regarding the petitioner, whether the society is a registered one. Lordship, it has come to my knowledge that the society has not renewed its registration since it was registered. So now,
So now what is to be done, ma'am? If you are not a registered society,
Lordship,
you will have to withdraw and you will have to file a petition
Afresh, Your
individually.
Lordship. Yes, Your Lordship.
Individually.
As a
The
petition.
affected parties have to file individually. Okay, because as per your petition, all the petitioners are either the president or some office bearers of the society, which is not registered. So we cannot proceed on the basis of this petition. So you come up with a new petition
Yes,
and let the petitioners be those persons who are agreed.
All right, Your Lordship.
Okay? MS so-and-so, the learned counsel for the petitioner, submits that he has instructions to withdraw the petition with liberty to file afresh. Prayer is allowed. Petition is allowed to be withdrawn with liberty to file afresh. Okay?
Oblige, Your Lordship.
Obliged.
For admission, item number 21.
May I please, Lordship?
Yes.
My Lord, I may be allowed 3 weeks' time to file affidavit in opposition. I'm for respondent number 5.
Ms. Hester, what is this? What is the matter about?
Lordship, the matter relates to land dispute, Your Lordship, boundary dispute.
Boundary dispute.
Yes, Your Lordship. And arising of that, orders has been passed, Your Lordship. Even the state is yet to file counter here, Lordship.
Mr. Moa,
I have also not filed, Your
you have
Lordship.
also not filed.
I have also not filed. I
And
revisited this thing.
you are for?
Respondent number 5.
Five.
I'm 1 to 4, Your Lordship. State responsible.
Mr. Moa, you mentioned the then senior government advocate for the respondent number 1 to 4 and Mr. Taka Kichu, the learned counsel for the respondent number 5. 6 for 3 weeks' time to file the respective affidavit in opposition. Prayer is allowed, listed after 3 weeks. Any interim?
It's until further orders, Your Lordship.
Pardon?
It's until further orders. Interim is until further orders, Your Lordship.
Oh, until further.
Yes, Your
orders.
Lordship.
Okay.
For admission, item number 22.
Lordship, this I'm representing the state. I have not filed the counter, but considering the judgment in order passed by the department, passed by the division bench in Alamba case, which you have just below now, this pertains to.
Anyhow, Mr. Moa, you at least file your affidavit so that we can at least differentiate the facts.
Otherwise, if I file also, this is because serving for 29 years, 5 months. And then fixed work judge employee.
So at least you at least take that stand that they are not eligible to be regularized under this thing. At least you file your affidavit. At
Yes.
least. Okay, so that it will be more convenient for us. You will give a short debt.
Lordship,
Yes,
allow
sir.
me 3 weeks time because
Yes. Why keep the matter pending when it has been covered by the division bench?
department, it takes time, your Lordship, you are aware.
Mr. Moimchin, the Leonard Senior Government Advocate, 6 for 2 weeks' time
Lordship.
to file affidavit in opposition on behalf of the state respondents. Prayer is allowed, listed after 2 weeks.
Obliged.
Oblige.
For admission, item number 23.
Last time I took time for filing up the reply. My lord, I need some more discussion with my client, but he couldn't make it.
The same thing, what is the matter about?
My lord, what happened is that the person was forced discharged, but he was granted a pension as some rifle person.
Forced discharge but granted pension.
My lord. Then what happened is that they are trying to recover an amount of 12 lakhs something out of the pension.
Excess.
Yes,
Paid
that
in
is,
excess.
yes, that is what they are saying. Now they've already recovered the life salary, gratuity. Now they are still demanding that I should give an undertaking that I'll return another 5 lakhs plus.
What were you serving as? As a constable or as
Constable, yes. They call it rifleman.
Rifleman. Yes, Mr. Younger, I think you should be considerate.
Lordship, I have already filed my affidavit.
My lord, I have already received it.
What is that latest judgment? Rafiq Matsi.
My lord,
Rafiq Matsi.
my lord.
As per that, I think you have to consider.
My lord,
And central government has also issued notification as per that order. Right? I think you are well aware about that traffic masses.
my lord, I am not aware of that.
You are not aware, and
latest.
you just see, because central government,
My lord.
on the basis of the traffic masses case, they've also issued notification as to when it can be recovered, when it cannot be recovered.
My lord.
Especially for these fourth grade employees and all this third grade. I think recovery is, it has been restricted. So you'll see the notification issued by the central government also. I think it is the traffic masses case. The latest, I think there are 2-3 judgments on this recovery. And if the central government notification was with regard to the latest case, I hope Rafiq Masih is the latest case. So just have a check.
My lord.
Okay. Mr. Imti Longcha, the learned counsel, or the petitioner submits that he may be further allowed 2 weeks' time to have to get some instructions from the petitioner. Prayer is allowed, listed up to 2 weeks.
Much obliged.
For admission, item number 24.
Yes, Ms. Inaoli.
Your Lordship, here I'm yet to file counter, so kindly grant 3 weeks' time, Your Lordship.
I filed my affidavit, Lordship.
You filed your counter.
Yes, sir.
What is this case?
It's about pension, Lordship.
Pension.
Because the petitioner is seeking for revised pension. He retired in 2005.
Pardon?
He retired in 2005 as Registrar of the High Court. He is asking for revised pension from 2018. Government of Nagaland has come up with a revised pension scheme, Lordship, whereby the scheme will be effective from the date on the first forenoon of June 2010.
It will be effective.
Yes.
The revised pension will be effective from?
Will be effective from 1/6/2008, Lordship.
1/6.
After 1/6/2008.
After 1/6/2008. For those who have retired before that, they will not be eligible.
No. But he is seeking for revised pension from 2005, from the date of his retirement, 2005. A lot of communication has been made to the state.
Lordship, the petitioner is seeking to implement the revision of pension as per table 20 of A3 of ROP 2010, Lordship.
Which we cannot give. Government is framing its own rules, Lordship, and they are forcing the Office of the Accountant General to make it effective.
The ROP is government's rule, man.
Yes. And if he has to be given, Lordship, everybody who has retired has to get it. It's going to be a financial implication for the state.
Okay, let the state file the affidavit.
Lordship.
Lordship will be filing affidavit in reply to the counter affidavit filed by the
Of course.
respondent train.
The privilege is given to you. MS Inaoli, the learned government advocate, 6 for 3 weeks' time to file affidavit in opposition on behalf of the state respondents. Where is the law? Listed after 3 weeks.
So they are considering that.
Stop. Mr. So-and-so, the learned counsel for the petitioner is also allowed to file affidavit in reply to the affidavit in opposition filed by the respondent number
3 and 4.
3 and 4.
Filed by the respondent number 3.
Lordship. Obliged.
For admission, item number 25.
No, Mr. Lordship. Lordship, in the last occasion also, I've sought some time, Lordship. Lordship, I may be given another 2 weeks' time to file my affidavit. Lordship, my name has not been reflected.
What is this?
Lordship, it's regarding regularization of the service. I have been appointed against the post that was created, Lordship. I used Dr. Post. That was subsequently advertised by the department during the COVID time on temporary basis.
For the state?
For 2 and 3, the medical department, Lordship.
Oh, and for 1?
For 1, the Chief Secretary.
Ms. Ayemi, you're for 1. So yes, Mr. Jim.
Yes, Lordship. In fact, my affidavit will cover the Chief Secretary also.
Oh,
because it's apparently the decision of the department.
You are yet to file.
Yes, I'm here to file, Lordship. 3 weeks maybe got the Lordship. I've sought for time in
Mr.
the
Nuzul, the engaged counsel for the respondent number
2 and 3.
2 and 3. 6 for
3 weeks time, Lordship.
3 weeks time
Lordship.
to file affidavit in opposition on behalf of the state respondents. Where is allowed? Listed after 3 weeks. Okay.
Absolutely. Lordship. Lordship, my name may be reflected in the call sheet, Lordship.
Yes. The name of the learned counsel
And Mosaic.
and Muzur for the respondent number
2 and 3.
2 and 3 shall be reflected in the daily course list.
Obligation, Lordship.
Yes.
For admission, item number 26.
Yes.
Please, Lordship, I need some more time. I'm still waiting for the instruction from the department.
Okay. Sir, in Timso, the learned additional advocate general, 6 for 3 weeks time to file affidavit in opposition on behalf of the state respondents. Where is allowed? Listed after 3 weeks. Yes.
For admission, item number 27.
Yes, Mr. City.
May I please, Lord?
What is the matter?
This matter relates to freezing of BDB funds for the last 8 years. Lordship may recall, in 2014,
No, what fund?
BDB, Village Development Fund,
Misusing or
frozen by the government. Because Lordship may recall, in 2014, there was a clash in Tendang Saddle. That is a border area between Chang territory and Yemkyong territory. It is an establishment where there was a clash of two communities, and few Yemkyong communities were displaced in view of that clash.
Okay.
And thereafter, there was some law and order problem. Not only this village, as many as 3-4 villages, the VTB fund has been frozen. But other villages have been restored on the ground that normalcy has returned. Because people who has abandoned the place in their absence, if the PTV fund is distributed, then definitely they will be left out. That is the reason why it was frozen at that point of time. Now that 7-8 years has passed, in respect of other villages, they have already opened it, left it, the ban.
How many years, for how many years it was frozen?
It is 8 years now, counting this year. And it is...
It is continuing?
Yes, very difficult to manage
Yes,
with...
Mr. Moa, you are still freezing VDP's fund till now. And whether actually the petitioner's village is a recognized village?
It's a recognized village.
Why don't you give them fund?
No, Lordship, problem is that, as per the, you are aware, Section 22 of the Village Council Act, the village council is under the district administration. So in the base of, in the rest of the village, we have done that. We have done that because normalcy has not been come to the village. Conflict is still
Even
there.
till now?
Even till now.
That is not correct, Lord. Even the case which was registered, that has been closed as perfect as in 2022. 12/9/2022, I have been closed the closure of the case also, page 29, annexure H. Case is already closed. And the miscreants, they were unable to trace who are the miscreants. So the case has been closed.
Which were the villages which was involved in the dispute? I think
The
the dispute was
two
between
villages
two villages.
were Chentang village belonging to Chang tribe and Yokor village belonging to Yumkyung tribe.
And you are for, in the
I am
present
for
petition,
Chentang village.
you are for Chandang village.
Yes.
Whether the
Chentang
funds,
settled.
whether the VDP funds has been released for Yokor village.
Yes.
Yes, Mr.
And then even the Uthor village, which is a neighboring village, which is inhabited by Yumkyung tribe. In their case also it is lifted. I have enclosed a copy of the order also, page 31.
Yes, Mr. Ma,
Yes, Your Lordship.
when the government is releasing the fund to the other villages which were in conflict with the petitioner's village,
Yes.
why actually the fund is not being released to the petitioner's village?
Lordship,
You have
Lordship,
released the fund to the other villages.
Lordship, me, please come to para 5 of state counter.
Okay, what do you say?
Para 5 of my
Yes, what did you say?
Lordship. That with regard to the statement made in para 8 of the read petition, the answering deponent offers no comments to the action born out of records. However, it is pertinent to mention herein that the memorandum and prayer for lifting of Chantang Settle Village suspension was written to the Commissioner Nagalit by the Deputy Commissioner of Tuisang on 1/11/2022. The leader suggested on a sitting of a joint consolidated body involving the district administration and the tribal bodies of Chang and Yimkyong by appropriate authority. The main aim was to address the issues holistically through some mediation without further aggravating the issue after both sides have addressed their concerns. However, no further directives has been issued from the higher authorities in this regard. We want to solve the problem and then release the payment. That is all. Nothing.
So they are also at least they are saying that they will release the fund, but their side the government is saying that actually the issue still remains unresolved.
That is what. That is
We
what.
want to resolve it in a holistic manner. We have no objection to that. In the process of doing that, what compels the government to withhold the VTV fund? Village is not developed.
Your Lordship, allow me 2 weeks' time. Let me confirm in
At least see.
at least
It is very good.
because apart from this, there will be reasons as to why this is being done.
If there is
Because state
reason,
government
then-
cannot do something. If something is very wrong, there. That is why, allow me 2 weeks' time.
We are in agreement with where the government is trying to do something very good for both the villages to maintain proper law and order situation. That is a very good gesture. But at the same time, if you are paying the development fund to the other villages which is in conflict, why don't you apply the same yardstick? So that at least a development fund can be given to the petitioner's village, and they can also be allowed to
develop.
develop themselves. So
That is-
please, you take care. Please see that you release the fund. Okay, we'll give you 2 weeks time.
Yes.
But you
Yes.
you impress upon the government.
Correct, Your
Okay,
Lordship. I'll
you
do that.
impress upon the government that to take steps for resolving the issue. That's very good. But at the same time, why leave out the petitioner's village from this developmental activities?
Yes.
Why denying them the fund?
Yes.
So on that line, you actually have a discussion with the government.
Yes.
We'll give you 2 weeks time. Let's see that the funds are released. With your good initiative.
Yes.
Okay.
Lordship.
Mr. Kumar, action. Then government. Let's start. The government is taking all necessary steps to resolve the conflict which is existing between the petitioner's village and the other village. And that was
Mkong village and district administration also.
Yakhor village.
You are which village?
I'm Chentang Saddle,
And the other is Yokor village.
Yakhor village.
And Yokor village.
including district administration, Your Lordship.
What was the sentence which I have taken? No. I didn't get it. Okay, anyhow, by the district administration. And the developmental funds to the petitioner's village shall be released on resolving the issue between the two villages. The Leonard government advocate,
Correct.
therefore, 6 for 2 weeks' time to receive necessary instructions.